వెల్కమ్ ఫర్ సెంటర్ ఫర్ సోషల్ డైలాగ్. మనం గత దాదాపు 28 సెషన్స్గా, దిస్ ఈస్ ది 28th సెషన్ అండి ఫర్ ది సెంటర్ ఫర్ సోషల్ డైలాగ్. వీఆర్ డిస్కసింగ్ అబౌట్ వేరియస్ ఇష్యూస్ టచింగ్ అపాన్ ది ఇండియన్ పాలిటీ, అంటే పౌర నాగరిక సమాజానికి సంబంధించిన అనేక విషయాల్ని మనం ఇక్కడ చర్చించుకుంటున్నాం. అందులో భాగంగా ఇప్పుడు మనము వేరియస్ ఫిలాసఫీస్ లైక్ గాంధీయిజము, లిటరేచరు, లాంగ్వేజ్, అన్ని రకరకాల కొన్ని జీవిత అనుభవాలను కూడా షేర్ చేసుకున్నాం. అలాగే ఉమెన్ హెల్త్, ఇలా అనేక ఇష్యూస్ మనం షేర్ చేసుకున్నామండి. టుడే ఎస్టర్డే మనకి నేషనల్ లా డే జరిగింది. అంటే ఆ రోజున కాన్స్టిట్యూటెడ్ అసెంబ్లీలో ఇండియన్ కాన్స్టిట్యూషన్ ఈజ్ అడాప్టెడ్ బై ది కాన్స్టిట్యూషన్ అసెంబ్లీ. సో దీన్ని మనము 1979 ఆన్వర్డ్స్ దీన్ని మనము లా డేగా లేదా కాన్స్టిట్యూషనల్ డేగా సెలబ్రేట్ చేసుకుంటున్నాము. అయితే మన సెషన్స్ అనేవి ఎప్పుడు సాటర్డే ఉంటాయి కాబట్టి మనం ఇవాళ ఆన్ ది అకేషన్ ఆఫ్ ది నేషనల్ లా డే ఆర్ ది కాన్స్టిట్యూషనల్ డే ఇవాళ మనము ఒక విశిష్టమైనటువంటి వ్యక్తిని ఇన్వైట్ చేశాము. వారి పేరు శ్రీ జి జయప్రకాష్ బాబు గారు. ఆయన ఏపీ, తెలంగాణ రెండు ప్రాంతాల్లోనూ చాలా వెల్ నోన్ అడ్వకేట్. వారు తూర్పు గోదావరి జిల్లా సఖినేటిపల్లికి చెందిన వారు. తను బిఎస్సి బిఎల్ చేశాక 1982 జనవరిలో వారు ఆంధ్రప్రదేశ్ బార్ కౌన్సిల్లో న్యాయవాదిగా నమోదు చేసుకున్నారు. తర్వాత వారి మరొక విశిష్టమైనటువంటి గొప్పతనం ఏంటంటే, మనకు తెలిసినటువంటి చాలా గొప్ప న్యాయమూర్తి, సుప్రీంకోర్టు న్యాయమూర్తి జస్టిస్ కె రామస్వామి గారు. రామస్వామి గారు హైదరాబాద్ లో అడ్వకేట్ గా ప్రాక్టీస్ చేస్తున్న టైంలో మన శ్రీ జి జయప్రకాష్ బాబు గారు వారి దగ్గర వారి ఆఫీసులో పనిచేశారు. తర్వాత శ్రీ రామస్వామి గారు హైకోర్టు జడ్జిగా, ఆ పైన సుప్రీంకోర్టు జడ్జిగా కూడా అయ్యారు. అలాగే ఆ తరువాత శ్రీ ఆదినారాయణ రాజు అనే ఇంకొక ప్రముఖ న్యాయవాదితో కూడా కలిసి పనిచేశారు శ్రీ జి జయప్రకాష్ బాబు గారు. అలాగేనండి అనేక మంది, అంటే శ్రీ ఎం రామయ్య, పి సీతారామరాజు, ఇలాంటి అనేక మంది సీనియర్ అడ్వకేట్లతో కలిసి పనిచేసి ముఖ్యంగా డిపార్ట్మెంట్ ఆఫ్ సోషల్ జస్టిస్, గవర్నమెంట్ ఆఫ్ ఆంధ్రప్రదేశ్ తరఫున ఆయన సోషల్ జస్టిస్ థియరీస్ యొక్క ఫండమెంటల్స్ ని అక్కడ నేర్చుకున్నారు. ఆ తర్వాత ఇటు ఏపీ అడ్మినిస్ట్రేటివ్ ట్రిబ్యునల్లోను, ఏపీ హైకోర్టులోను దాదాపు 14-15 ఏళ్ల పాటు గవర్నమెంట్ ప్లీడర్ గా అనేక డిపార్ట్మెంట్లకి పనిచేశారు. ఆ తరువాత సెంట్రల్ గవర్నమెంట్ తరఫున 2005 నుంచి దాదాపు 2014 దాకా, ఇంకా 15 దాకా కూడా 11 ఏళ్ల పాటు సుదీర్ఘంగా సెంట్రల్ గవర్నమెంట్ అడ్మినిస్ట్రేటివ్ ట్రిబ్యునల్లో సీనియర్ స్టాండింగ్ కౌన్సిల్ గా పనిచేశారు. తర్వాత 40 ఏళ్ల తన సుదీర్ఘమైనటువంటి న్యాయవాద వృత్తిలో ఆయన అనేక పదవుల్ని తీసుకున్నారు, అనేక ఇంపార్టెంట్ పొజిషన్స్ ని హోల్డ్ చేశారు. అలాగే భారత రాజ్యాంగం పైన, డాక్టర్ అంబేద్కర్ పైన, దళిత సమస్యల పైన అపారమైన అవగాహన ఉన్నవారు. ఈవేళ జయప్రకాష్ బాబు గారు డాక్టర్ అంబేద్కర్ గారి రాజ్యాంగ రచనలో డాక్టర్ అంబేద్కర్ గారి రోలు, అలాగే పౌరులకి ఆయన హక్కులు కల్పించిన పద్ధతి, ముఖ్యంగా అణగారినటువంటి వర్గాలైన దళితులకి, అలా ఎస్సీ ఎస్టీలకి అతను ప్రత్యేకంగా హక్కులను నిర్వచించడంలో అతను తీసుకున్న కృషి, ఇవన్నీ కూడా ఇవాళ డాక్టర్ మన శ్రీ జి జయప్రకాష్ బాబు గారు, ప్రముఖ న్యాయవాది గారు మనతో మాట్లాడతారు. నౌ ఐ వెల్కమ్ శ్రీ జి జయప్రకాష్ బాబు గారు టు డెలివర్ హిస్ లెక్చర్. సార్, యూ కెన్ టాక్ టు సార్. వెల్కమ్ జయప్రకాష్ బాబు గారు.
థ్యాంక్ యూ మై డియర్ ఫ్రెండ్ అండ్ కొలీగ్ మిస్టర్ రఘుకుమార్, డాక్టర్ రఘుకుమార్ గారు. థ్యాంక్ యూ వెరీ మచ్ ఫర్ యువర్ కైండ్ వర్డ్స్ delivered in my career. Really, I have a very great occasion you have created, and this is really, I appreciate when you have called me to interact with our friends. So, my dear friends, yesterday we have celebrated the 72nd Constitution Day. You are all aware how our Constitution is working as of now. In our Constituent Assembly, the 26th November 1949, do hereby adopt and enact and give ourselves this Constitution. The Constituent Assembly elected Dr.B.R.Ambedkar as chairman of the drafting committee to frame the constitution for free India, for the reason that one, okay, something is wrong here.
Yes, sir. Yeah, everything is going on well.
Well,
yeah, right.
One, he was alone eminently suited to draft the constitution as he was the best educated member of the assembly. He had the unique distinction of having an American doctorate in philosophy, a London doctorate in science, and a London barrister at law. Secondly, he had a vast experience as an educationist, lawyer, parliamentarian, and administrator, and also associated with all the major constitutional developments in the country and abroad. Okay, the drafting committee consists of 7 members, out of 1 member had resigned. 1 member was died. 1 member was always in America, and the another member was engaged in state affairs, and 2 were away from Delhi in personal reasons. So it happened ultimately that the burden of drafting of the constitution fell on Dr.B.R. Ambedkar. Dr. Ambedkar drafted an elaborate constitution with 395 articles and 12 schedules in less than 6 months, from 29th August 1947 to 21st February 1948. My dear friends, after marathon debate on each clause, the Constituent Assembly, with the suitable amendments, adopted the Constitution on 26 November 1949. It was one of the best constitution among the democratic countries in the world. Dr. B.R. Ambedkar has praised by all the members of the Constituent Assembly as father of the Constitution. In this context, I would like to invite you all to the Constituent Assembly, the speech of Dr. B.R. Ambedkar in the Constituent Assembly. Some of the relevant phases in the speech of Constituent Assembly, I would like to take you all up. On 25th November 1949, Dr. B.R. Ambedkar, in his speech in the Constituent Assembly, has elucidated the meaning of social and political democracy as follows. The third thing we must do is not to content with mere political democracy. We must make our political democracy as a social democracy as well. Political democracy cannot last unless there lies at the base of its social democracy. What does social democracy mean? It means a way of life which recognizes liberty, equality, and fraternity as the principles of life. We must begin by acknowledging the fact that there is a complete absence of 2 things in Indian society. One of this is equality on the social plane. We have in India a society based on principles of graded inequality, which means elevation of one and degradation of others. On the economic plane, we have a society in which there are some who have immense wealth as against many who live in abject poverty. On the 26th January 1950, we are going to enter into a life of contradictions. In politics, we have equality in social and economic life. We have social and inequality in life. In politics, we will be recognizing the principle of one man, one vote, and one vote, one value. In our social economic life, we shall, by reason of our social and economic structure, continue to deny the principle of one man, one value. How long shall we continue to live this life of contradictions? How long shall we continue to deny equality in our society and economic life? If we continue to deny it for a long, we will do so only by putting our political democracy in peril. We must remove these contradictions at the earliest possible moment, or else those who suffer from inequality will blow us the structure of political democracy which Assembly has so laboriously built up. In the United States of America, there was no caste problem. In India, there are castes. These castes are anti-national in the first place because they bearing about separation in social life. They are anti-national also because they generate jealousy and antipathy because caste and caste. But we must overcome all these difficulties. We will wish to become a nation in reality, for fraternity can be a fact only when there is a nation. Without fraternity, equality and liberty will be no deeper than coats of paint, but political power in the country, in this country, has too long been the monopoly of a few, and the many are not only beasts of burden, but also beasts of prey. The monopoly has not merely deprived them of their chance of betterment, it has shaped them of what may be called the significance of life. These downtrodden classes are tired of being governing, they are impatient to govern themselves. This urge for them for self-realization in the downtrodden classes must not be allowed to devolve into a classes of struggle or class of war. It would lead to a division of the house that would indeed be a day of disaster. I would also take you the preamble of the Constitution. The preamble of the Constitution proclaims India a sovereign, socialist, secular, democratic republic, and to secure all its citizens justice, social, economic, and political liberty of thought, expression, belief, and faith and worship, equality of status and opportunity, and to promote among all fraternity, assuring dignity of the individual and the unity and integrity of the nation. Dr.B.R. Ambedkar, in the closing speech in the Constituent Assembly, has warned that social and political democracy is a way of life which recognizes liberty, equality, and fraternity as the principle of life. They are not to be treated as separate items in the Trinity. They form an integral union. One cannot diverge from other. Otherwise, it would defeat the very purpose of democracy. Without equality, liberty would produce supremacy of a few over the many. Equality without liberty would kill the initiation to improve the individual excellence. Political equality without social economic equality would run the risk of democratic institution to suffer a setback. Therefore, for establishment of a social order in which social and economic democracy would be a way of life, inequality in income would be removed, and every endeavor be made to eliminate inequalities of status through the rule of law. This is what Dr. Ambedkar has said. After framing the Constitution, this would be very relevant for the purpose of our meeting. That is how Dr. B.R. Ambedkar was praised. Dr. B.R. Ambedkar drafted an elaborate constitution, as I have said. Here, my dear friends, after marathon debate on each clause in the Constituent Assembly with a suitable amendment, adopted the Indian Constitution on 26 November 1949. It is one of the best constitution among the democratic countries. Then, after going to the Constitution, Sri T.T. Krishnamachari, one of the member of the drafting committee, has praised Dr. Ambedkar and said, I quote, that I have no doubt that we are grateful to Dr. Ambedkar for having achieved this task in a manner which undoubtedly commendable. Dr. Rajendra Prasad, President of the Constituent Assembly of India and later first President of the Indian Republic, paid the tributes to the excellent work turned out by Dr. Ambedkar and has said, I quote, that I have realized nobody else could have with what zeal and devotion the members of the drafting committee and especially its chairman, Dr. Ambedkar, in spite of his indifferent health, have worked. We could never make a decision which was or could be ever so right as when we put him on the drafting committee and made him its chairman. He has not only justified his selection, but has added luster to the work which he has done. I unquote. Jawaharlal Nehru had remarks about Dr. Ambedkar in the drafting of the Constitution of India. I quote, Dr. Ambedkar had played a most important part in framing the Constitution. No one took greater trouble and care over Constitution making than Dr. Ambedkar. I unquote. Therefore, it was almost universal exclamation of the Herculean task carried out by Dr. Ambedkar. Even those intellectuals, journals, newspapers, and politicians who had sharp disagreement with Dr. Ambedkar's views were forced to admire his outstanding ability and that, my dear friends, Dr. Ambedkar is a great jurist of the world, statesman, scholar, educationist, social revolutionary, the intellectual giant of India. He is a great emancipator and a liberator of the downtrodden and exploited sections. Therefore, friends, I would cite one judgment of the Supreme Court in which it was very much dealt with about Dr. B.R. Ambedkar and said, the Honorable Supreme Court in the case of Arunachal Pradesh reported in 2016, 8 SCC page 1, in deciding discretionary powers of the government under the governor under Article 163 has quoted the speech of Dr. Ambedkar in the Constituent Assembly by addressing him as Honorable Dr. B.R. Ambedkar. Therefore, friends, Dr. Ambedkar was very much honored by not only by the people of this country, but also the very important wing of our democracy, that is judiciary. My dear friends, I would like to take you to the various provisions of the Constitution which the Supreme Court has an occasion to consider and held that right to life is a fundamental right. Right to life, right to health, and right to education are declared as fundamental right by the Honorable Supreme Court, reported in AR 1991 SC, page 41, 1995 3 SCC, page 342, and Air India Statutory Corporation case reported in AR 1997 SC, page 645, and in Papaya's case reported in 1996 10 SCC, as specifically held, right to health, right to education, and right to life are fundamental rights. Therefore, my dear friends, the Supreme Court has taken into account how the Constitution has working out as of now. In this context, I would like to take you to the various provisions of the Constitution under which the rights of the scheduled caste and scheduled tribes were protected. If you take Article 335, Article 335 enjoins the states to take into consideration the claims of SCs and STs, making appointment in government services may be subject to maintenance of efficiency, etc. Article 16(4)(a) provides for reservation in the matters of promotion and consequential seniority. This is the most important issue now. Most of the employees are now discussing about. Provides for reservation in the matters of promotion and consequential seniority to any class or classes of posts in the services under the state in favor of SCs and STs, which, in the opinion of the state, is not adequately represented in the service under the state. My dear friends, I would like to take you various judgments of the Honorable Supreme Court in this context. This would help many of us to know how the rights of the SCs and STs are dealt with by the Honorable Supreme Court. In the case of Rangachari, reported in AR 1962 SC, page 36, the Honorable Supreme Court has held like this. In the said case, the question was whether the reservation in promotion to the selection grade post in railway service to SCs and STs is valid. The Constitution Bench, 5 judges per majority, held that the reservation in clause 4 of Article 16 would encompass promotion in selection grade of posts. In Kerala judgment, the Kerala government amended the service rules extending 3 years for the SCs to pass the departmental examination and promotion given pending passing of such examination. When the rule was questioned, the Honorable Supreme Court in the case of Thomas case reported in 1976 2 SCC page 310 by a larger bench of 7 judges held, this is very important, equal opportunity for employment under the state guaranteed under clause 1 of Article 16 applies to promotions to SCs and STs, promotions under SCs and STs under Article 16(1) itself. SCs by 344 is for the purpose of constitution and it is not caste. As such, it was held that by reason of provision of Article 16(4) of the Constitution, a treatment to the members of SCs and STs different from that of to others in the matters relating to employment or appointment to any office under the state does not violate the fundamental rights to equality of opportunity to all citizens in such matters guaranteed under Article 16(1). Ultimately, what the Supreme Court has said was, in the subsequent judgment I will take to you. In the state of Kerala versus Thomas, that is what I have referred earlier. The efficiency of administration may not require high degree of qualification. There the question was, there is no efficiency in that. The efficiency of the administration may not require high degree of qualification in this context, but the minimum which is necessary to maintain administrative efficiency. This was held by the Honorable Supreme Court in the case of Thomas, reported in 1976, 2 SCC page 310. In ABSK Sangh versus Union of India, reported in the AR 1981 Supreme Court, 298, dealing with the efficiency in Article 14, 16 and 46. Inefficiency of Article 335, the Honorable Justice Krishna has observed like this. This is very important for the purpose of protecting the rights of the scheduled castes and scheduled tribes. The trite argument about efficiency and inefficiency are a trite phony, because after all, at higher levels, the SC citizens appointees are a microscopic percentage. And even in the case of class 2 and class 3 posts, they are negligible. The preponderant majority coming from the unreserved communities are presumably efficient, and the dissolution of efficiency caused by the minimal induction of a small percentage of reserved candidates cannot affect the overall administration of efficiency significantly. Indeed, it will be a gross exaggeration to visualize a collapse of the administration because of 10% of the total number of officials in the various classes happen to be substandard. Moreover, care has been taken to give service to correct deficiency. Then we will come to the very burning issue now about the reservations in promotions. In Indra Sahani's case, this is Mandal's case, a 9-bench judgment of the Honorable Supreme Court reported in AR 1993 Supreme Court page 447 held, as I pointed out earlier, in Rangachari's case, the initial appointment and also in the promotions, reservations can be given. In this case, in Indra Sahani's case versus Union of India, 9 judges judgment, reported in AR 1993 Supreme Court 446, held a majority that the claims of SCs and STs are to be taken into consideration, that the reservation of appointments of posts under Article 16(4) is confined to initial appointment only and cannot extend to provide reservation in the matters of promotion. This is the controversy now going on, and one after the other number of judgments are coming from the Honorable Supreme Court. I will cite one of the several judgments on this aspect. So in Indra Sahani's case, that Mandal's case, though the issue is not there, whether SCs and STs are entitled for promotion, reservation in promotion or not, but the Honorable Supreme Court in this judgment, reported in 1993, Mandal's case, said Only in the initial appointments, reservations are provided, and no reservations in promotions. That is exactly what was held by the Honorable Supreme Court in Mandal's case. Then the Parliament amended Article 16(4) of the Constitution, that is 77th Amendment, Amended Act 1995, incorporating Clause A of Article 16(4)A, reads as follows. Nothing in this article shall prevent the state from making any provision for reservation in matters of promotion to any class or classes of posts under the state in favor of the scheduled castes and scheduled tribes, which in the opinion of the state are not adequately represented in the services under the state. This is the amendment brought in 1995. Therefore, my dear friends, then what happened was a catch-up rule was evolved by the Honorable Supreme Court. That is Veerpal Singh Chauhan's case. Catch-up rule was brought in. That is reported in. That is Veerpal Singh Chauhan reported in 1995, 6 SCC page 648, in which was negated by the Constitution. Then what happened was, this was when the Constitution amendment was brought in, this Veerpal Singh case came in. Then this was a catch-up rule was evolved. Then the government has brought an amendment to the Constitution, that is 85th Constitutional Amendment Act, by amending the text of Article 16(4)A. Then this was also under challenge before the Honorable Supreme Court in the case of M. Nagaraj versus Union of India, reported in 2006 8 SCC page 212. The Supreme Court has held like this. Reservations in proportion could be affected only on the basis of quantifiable data regarding underrepresentation has been done. This is the judgment that was held in 2006. Then again this was subjected to another judgment of the Honorable Supreme Court in the case of Jarnail Singh versus Union of India, reported in 2018 10 SCC page 396. The Honorable Supreme Court has held that the catch-up rule was introduced in Pavitran's case, and the Honorable Supreme Court has further held the extension of government servants' promotion on the basis of reservation is not valid. Thereafter, in Paneer Selvam's case, the Honorable Supreme Court has held that in respect of the higher post, the principles of reservation may even be done away with completely in the interest of efficiency of administration. This is how the Supreme Court from time to time has, in its wisdom, or I can call it as in its interpretation, has been holding, in spite of the fact in Rangachari's case, Rangachari's case has specifically held 30 years ago. In fact, that was 30 years ago, has held that reservations in promotion under Article 16(4) is not only in the initial appointments, but also in the reservations in promotions can be affected. Therefore, from time to time, the Honorable Supreme Court, one after the other, has been holding. I can say that has been scuttling down the reservations in promotions by holding that there is a catch-up rule and there is a quantifiable data, and all these things were introduced one after the other. After scanning all the above judgments, all should visualize how the Supreme Court has dealing with the rights of SCs and STs in providing the reservations in the relating to the service matters. Therefore, my dear friends, this is I can say that there is something more to take all of you, for the reason that I have my opinion on how the Supreme Court has occupied most of the vacancies, and I got the statistics also. I think it may not be necessary for the reason our subject is very limited, and I don't want to go beyond that. Therefore, my dear friends, Dr.B.R. Ambedkar was praised because of his great knowledge and work done for the nation, for building up the nation, and for protecting our rights. This is the rulers have to keep in mind the spirit of the Constitution instead of framing a different agenda of their parties. And for that, I would, in fact, I wanted to tell more about, to comment on the present governments, how they are getting their agenda instead of implementing the spirit of the Constitution. And I don't want to take that except saying that Dr. Ambedkar, who lived for others, has lived forever. And throughout his life, he had suffered and lived for suffering humanity and nation building, and for social justice and secure dignity of a person of the weaker sections of the segment. Dr. Ambedkar was born on 14th April 1891, and died on 6th December 1956. Therefore, his entire life, he fought for the nation building after having a lot of experience, not only in the country, not only for the sufferers, but also to achieve equality, particularly equality. And he has given a lot of experience to devolve, not only to educate the people and to organize and to agitate for their rights. Therefore, friends, Dr. Ambedkar has done a lot of hard work for nation building, and therefore we should remember how Dr. B.R. Ambedkar has done for not only to scheduled castes, but also for building the nation. Therefore, I once again thank Mr. Raghu Kumar for giving me this opportunity. Because of short notice, I have my own ideas in exploring before all of you. But this happened to be the first meeting. I have my own limitations because my understanding and my knowledge on Dr. B.R. Ambedkar can be expelled before all of you. Therefore, my dear friends, I am very much grateful to Mr. Dr. Raghu Kumar and the audience for bearing me for these few minutes. Thank you. Thank you, one and all.
Thank you, wonderful Dr. Jayaprakash Babu. You have been a wonderful lecture today. And in fact, when you are talking, I felt as if you are arguing a case in a court of law, especially in the higher forum of the court of law. So
because we are adjusted with that for a long time, no?
Yes. I felt as if you are seriously arguing a case on behalf of the Dr. B.R. Ambedkar, the rights of the SCs and STs, and that too in the highest forum of law in our country. I felt like that, really. I'm really thankful to you, Prakash Garu, the Jayaprakash Babu Garu. It's a wonderful session. In fact, we would like to hear you in future also on many possible occasions. Because you are
Thank you.
You are a source of knowledge. I could understand from your brief talk. The man who knows more can also talk very briefly. This is the beauty of a well-informed person will always be brief in his expressions. So you have done a wonderful job. You have
the reason I would like to tell you, because I thought our audience are always having a knowledge in what is this called, expanding our speech.
Yes.
Because if we indicate our mind, they can always expand, and they will mold it in a way which it's suitable for them. Exactly. Therefore, my whole speech, or whatever you call it, is only limited for the purpose of indicating how the Supreme Court has held and what is the constitutional rights of our citizens, not only for SCs and STs. The Constitution is provided in all the English department. Democracy, the legislature, executive, and judiciary has its own independent roles. Yes. Therefore, all these things has to be read together. One wing cannot encroach into another wing. That is what all of you know about that. Therefore, my all endeavor was only to indicate how the government is working. Their agendas are totally different. They are not at all working under the spirit of the Constitution. This is what I wanted to tell you all.
Welcome.
Their agenda is totally different. They wanted to what is this promulgate their own ideas. They are not at all in the sense where they have, in spite of the fact the Supreme Court is deciding the people's rights, the governments are totally working on their own agendas.
Exactly.
Therefore, this is what the people should aware of. There is a constitution. It will holding the field. So long as the earth is there, the constitution will be there.
Yes.
Therefore, so long as India is there, the constitution is there. Therefore, we should be aware of the constitutional provisions and attack the government or attack the rulers by taking our rights to the courts and see that should be implemented.
Wonderful.
Through execution.
Wonderful, sir. Wonderful.
Therefore, my dear friends, that's the reason I was very brief in giving my speech, or whatever you call it, my lecture.
Yeah, it's only man of wisdom can always be brief.
Thank you. Thank you.
So, sir, today on the occasion of the Constitutional Day or the Law Day or the Lawyers Day on 26th 11 of every year, మనం ఇవాళ శ్రీ జి జయప్రకాష్ బాబు గారు చాలా వెల్ నోన్ అడ్వకేట్ ఇన్ ద 2 states of Telugu speaking states and a well known person for academic Ambedkarite philosophy and also the constitutional philosophy, has given a wonderful lecture. In fact, we have given him 45 minutes to 55 minutes, but he tried to be as brief and as tidy as possible in his lecture. It's a wonderful session. So now I